is what are the significance of these laws as well as the associated challenges and concerns is what we will actually discuss about, and what is the importance for reforming the Indian criminal justice system is also very, very important for the examination. Okay, so here we will be discussing about the new criminal laws that have been brought into existence and also India's criminal justice system. And this particular topic can be mapped to the government policies and interventions as well as the Indian constitution and historical underpinnings under polity and governance under GS paper 2 for both your prelims as well as the mains examination. Now moving forward, let us actually see a similar question that has been asked in the past in the mains examination. Specifically, if you see in the year 2017, there was a question on mob violence is emerging as a serious law and order problem in India. By giving suitable examples, analyze the causes and the consequences of such violence. So, what are the provisions of mob violence or terrorism, then kidnapping, trafficking, all these things, and what are all the provisions and which actually covers, which are all covered under these criminal laws become very, very important for you to know. So, let us actually discuss what this particular article is discussing about. Okay. So, the new criminal laws, that is the Bharatiya Nyaya Sanhita, the Bharatiya Nagrik Suraksha Sanhita as well as the Bharatiya Sakshya Adhiniyam, that is the BSA, are taking effect from 1st of July 2024. So, now let us understand what are these criminal laws and what are the criminal laws that were already existing that were replaced by these criminal laws. Okay. So, if you say the Bharatiya Nyaya Sanhita will be replacing the Indian Penal Code, okay, of 1860. Indian Penal Code is nothing but it is the official criminal code of India that was actually drafted in 1860. You know, few years later, the first law commission actually came into existence in 1834 after this particular Charter Act of 1833. So, our takeaway from this particular discussion is what is IPC, when did it come into existence, what does it actually entail, what was the first law commission, what were the provisions and recommendation, and also what are the provisions of this particular Charter Act. All the Charter Acts, all the Government of India Acts are very, very important as they can be asked as one of the statements specifically in your MCQs in your prelims examination. Now, moving on to the next one, the Bharatiya Nagrik Suraksha Sanhita, that is first one BNS will actually be replacing the IPC, and then BNSS, that is Bharatiya Nagrik Suraksha Sanhita, will be replacing the CrPC, that is the Code of Criminal Procedure that came into existence almost in 1974, and that actually provides procedure for administering criminal law in India. And finally, the Bharatiya Sakshya Adhiniyam, that is the BSA, will be replacing the Indian Evidence Act of 1872, and this particular Indian Evidence Act was actually passed in India by the Imperial Legislative Council during the British Raj, and it also contains a set of rules as well as allied issues governing the admissibility of evidence in the court. So, what kind of evidence is actually taken up by the court as a proper evidence against a convict or a victim? This is what this particular law talks about. Now, moving forward, we actually looked into what are these laws and what are the existing laws that they had replaced. Now, we need to understand why was there a need for the replacement of these laws. Okay. First, we need to understand that these laws were actually outdated. That is the IPC, CrPC. They actually had, they were colonial of origin. That is the thing that we need to understand. They were complex, they were ambiguous, and they did not actually suit the contemporary and the changing social dynamics of the society. Okay. So, that we'll actually be looking at it and we'll be substantiating it with proper examples so that it's easier for us to understand. So, first, why is there a need for the new criminal laws? First thing, it is outdated colonial legacy. The current laws are based on the colonial era principles, that is IPC and CrPC, and they do not reflect the modern Indian society's realities as well as aspirations. For example, if you see section 377 of the Indian Penal Code, that actually criminalized the same-sex relationship, okay, but that was actually struck down by the Supreme Court in 2018, and that is why we say that it is not aligning with the contemporary values of equality as well as non-discrimination. The second one, if you see, these laws are actually complex and they were very, very ambiguous. For example, they are outdated, they are complex and ambiguous. That actually leads to further delay, further inefficiencies as well as injustices in delivering justice. For example, the Nirbhaya gang rape case actually took around 7 years to actually come to its final verdict, okay, which is very, very concerning. Next one is the evolving nature of crime. Okay, with the advent of information and technology as well as artificial intelligence, the nature of crime itself has actually changed. It's no more restricted to murder, etc. But now you have also cyber crimes. Okay, so crimes are actually constantly evolving, but the laws actually remained intact. Okay. Next one, they are actually misaligned with that of the constitutional values. Okay, so here it means that laws are not aligned with the Indian constitutional values like equality, dignity, secularism as well as human rights. For example, if you see sedition law, which is actually mentioned under section 124A of the IPC, has been criticized for stifling, that is for curbing the freedom of speech and expression, which is of course a fundamental right enshrined under the constitution. So again, one more takeaway is to understand what are all the fundamental rights, the key provisions, the articles associated with the same, etc. The next one, there are a lot of instances of human rights violation. Here, the Indian criminal justice system is often accused of violating the human rights, including custodial torture. And this has actually been a case, of late. For example, in 2020, there were instances of Jairaj and Binik's killing. In 2020, in Tamil Nadu. Okay, so this is also there. There are, false arrests that are being made. There are extrajudicial killings that are actually made. So all these should be taken care of. Okay. Now moving forward, let us see what are all the key changes that have been made. What are the changes that were already not there in the IPC and the CrPC, and what have been included under all these BNS is what we'll quickly go through. First one is Bharatiya Nyaya Sanhita, that is BNS. First, new crimes have been included under its ambit. That is, clause 69 of BNS penalizes sexual intercourse. That is, having sexual intercourse in the name of marriage is actually a crime. So, through deceitful means or false promise to marry is punishable up to 10 years in prison and a fine. Next, clause 103 recognizes murder on the ground of race, caste or community as a separate offence. Next one, there has also been inclusion of organized crime and terror. Here, offences such as organized crime and terrorism, previously that was actually covered under specific laws of UAPA, that is Unlawful Activities Prevention Act, and state specific laws are now included in this BNS. Okay. Next one, 111 subclause 1, this defines organized crime to include activities, that is, it's given a proper specific definition to what are these organized crime. It includes activities like kidnapping, extortion, cyber crimes with severe consequences and human trafficking as well. The next one, removal of sedition. This is very, very important. Sedition has been removed and replaced with offences that endanger the sovereignty, the unity as well as the integrity of India. Earlier, this sedition actually did not have any specific definition. Now they are talking any activity that actually hampers the sovereignty, the unity and the integrity of India is actually called as sedition, and that is kept under BNS. Next one is community service. So this introduces community service as an alternative form of punishment for certain, very lesser severe offences. For that, community services is actually given as a compensation or a kind of a punishment. So that is why these kind of new criminal laws are actually said to be reformative in nature rather than terming it punitive. That actually gives you capital punishment or extreme form of punishment for your offences. Next one is mob lynching. As we saw, there was a question on mob lynching in the year 2017, the mains examination. So this particular BNS specifically recognizes and adds penalties for the mob lynching, reflecting a legislative response to the recent societal issues. Now moving forward, the next one is Bharatiya Nagrik Suraksha Sanhita. So what does it say? This actually has extended the period of police custody from the period of 15 days. Now it is actually 90 days. Okay. And this is for certain offences and this is expanded. Next one, trials in absentia. Here it actually says that trials and convictions can happen even if the accused is not present, rather than delaying the case further and further. Next one, removal of statutory bail. So this particular provision of BNSS has actually eliminated the provision for statutory bail if an accused faces multiple charges, and that is why they actually say this is actually tightened this bail condition. Next one, victim-centric approaches. Here there have been tighter timelines for the completion of the trials. Earlier there was no particular bar on when the particular trial actually has to be completed, and victims here have the right to be heard before the withdrawal of cases with the punishment of 7 years or more. And finally comes our Bharatiya Sakshya Adhiniyam. Okay, so here there has been recognition of electronic records. Okay, so here they are saying here digital records which are actually stored on your electric devices would be taken up as an evidence. Next one, there is also expansion of secondary evidence. This actually includes oral as well as written admissions, and expert examination on the document is also allowed. The next one, admissibility of electronic digital records. This is what we also saw. So, apart from the very traditional paper records, this has also been included under our BSc. Now moving forward, let us actually quickly go through what are all the significance of the new criminal laws that have actually come into effect. So as I told you, here it is actually very reformative when compared to that of the punitive criminal laws that we had, beforehand. So the new laws actually seek to move towards a reformative justice system by providing for community service instead of imprisonment, we saw, whereas punitive justice, it focuses on punishing the offenders for their wrongdoing, while reformative justice actually is trying to give a kind of rehabilitation, okay, to address their criminal behavior. Next one, there is modernization. The new laws are also in sync with that of the advent of technology and the contemporary needs of the society. Next one is embracing technology, as we saw, and this facilitates the streamlined as well as expedited criminal proceedings. It actually helps in faster resolving of the cases as well. Next one, there is decentralization of power. Okay, the new laws actually shift the focus from government control, that is the centralization, to citizen-centered criminal justice, and thereby this actually emphasizes swabhasha, very important, that is native language, swadharma, that is individual duty, and swadesha, that is actually nationalism. Now moving forward, let us understand finally what are the concerns with the new criminal laws, because whenever we actually study a particular topic specifically for the mains examination, rather than focusing just on the advantages and the significance the particular laws will give, it is always good to know the other side of the coin, that is what are all the related challenges as well as the concerns. Okay, so here the concerns are over extended police custody, okay, because earlier it was 15 days and now they have actually moved to or expanded it to 90 days, and already there have been reported cases of custodial torture, etc. So this could actually enable the police torture, so this actually has to be taken into consideration. Next one, the broad definition of terrorism adopted from UAPA could actually be misused, okay, because the government can actually misuse this provision of the UAPA Act and sentence a person. The next one is all these three bills have been very hastily actually passed without adequate public consultation as well as proper discussion and debate. So this has also raised concerns about the transparency and responsiveness of the legislative process. So this is actually questioning the entire legislative process. So these are the concerns. So with this, we've actually come to the end of the live session by discussing a very important and a trending topic which is very, very important for your public policy, your polity as well as governance. So for more such updates and live sessions, please do like, share and subscribe to Narayana IAS Academy YouTube channel. Have a good day and thank you.